I'm not looking for an attorney to ride in on a white horse at this point. I know that's not realistic. My husband has been using our insurance claim money from the hail damage. It's $29,000, and he's been using it to bankroll his attorney and spend it on other items.
I don't want nothing to do with it or her. She can have the house. She can have whatever else.
Court will note the appearance of Mr. Umlauf on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for modification of legal custody, parenting time, support, and change of domicile. Mr. Umlauf.
Your Honor, the parties share one child born who is 6 years old. Their order regarding custody, parenting time, and child support was entered up September 17th of 2019. It dictates that the parties share joint legal custody and the plaintiff has primary physical custody of the child. Defendant was to have parenting time every Saturday from noon until Sunday at 6 p.m. Plaintiff in this matter is seeking to move to Tucson, Arizona with her fiance to better provide for her family through the better education employment opportunities that are afforded to her in Tucson. Under Vodvarka, the relevant facts are the defendant has abandoned the minor child for the last 3 years. Since the child was born, he only exercised sporadic parenting time and none for the last 3 years. The child just does not have a relationship with the defendant. There's a history of domestic violence by the defendant against client. A PPO was entered in favor of the plaintiff in the case 19-PP after the defendant punched her in the face in the presence of the child. He does not participate in any medical or educational decisions for the child. There is no bond of love, affection, or emotional ties between the child and the defendant, whereas there is a strong one between the plaintiff and the child, as she is the sole care provider. The child does look to the plaintiff for love, affection, and guidance, while the defendant is shown, due to his own inaction, that he does not have the capacity and disposition to give the child love, affection, and guidance. The plaintiff has been providing the child with a safe and satisfactory environment and has arranged and attended all of the child's medical and dental appointments. The defendant recently filed frivolous parenting time complaints after abandoning the child for the past 3 years. I believe this was motivated by the plaintiff's desire to move to Tucson. Looking at the factors for a legal permanent residence change, I would note that the plaintiff has been accepted into the Tucson College of Beauty, which will increase her earnings and earning potential. And this college provides financial aid and job placement upon completion of the program. College of Beauty is located in a bigger city, which has more opportunities than Battle Creek. The plaintiff's fiance has a job for himself and an apartment in Tucson, Arizona for himself, the plaintiff, and the plaintiff's children. This better living arrangement career opportunity will allow the plaintiff to provide better for her children. The school that the child will be attending in Arizona has a lower student to teacher ratio and more education-based activities that are offered by the school and the University of Arizona than the child's current school. Again, the defendant has failed to utilize his court-ordered parenting time. This is not because plaintiff is trying to frustrate the parenting time schedule. This is due to the defendant's own decisions. Therefore, it is possible for the court to modify parenting time to allow defendant to resume contact and begin a relationship with the child. We would suggest through phone calls, emails, Skype, or FaceTime, and only in-person parenting time once they are reacquainted. The plaintiff is not trying to secure a financial advantage here. This move would actually help the defendant's child support obligation, as she would have a greater earning capacity in Arizona, and is already having trouble keeping up with his child support payments, as shown by the show cause hearings. The plaintiff has filed similar motions for change of domicile in cases Cannon versus Martin, Cannon versus Ansley, where she has sole legal custody of the children, and those cases are pending before the referees. With that, Your Honor, we're requesting that the court order that plaintiff have sole legal and physical custody of the child, grant the requested change of domicile, and permit the plaintiff to move to Arizona. Order that the defendant have parenting time through video calls and phone calls until he is reacquainted with the child, and then parenting time as the parties agree. Order that the parties communicate through our family wizard or talking parents. Order and modify child support consistent with the Michigan child support formula. Thank you.
Thank you. Mr. Wines, what's your response?
My response to that is I've been trying to build a co-parenting relationship with Lyric for the longest, and that wasn't working. So we went through third party, which was my mom, and she just started vanishing, changing her phone number, and we would have good times. Like, we would be consistent on the parenting time. And then she had just ghosted and vanished. She knew where I lived. She knew where my mom lived. We never known where she's lived. We've never known her number. She constantly changes her number. So I've been trying to build a relationship with my daughter for the longest. I'm not out of my daughter's life. I'm not out of my daughter's life by choice. So with that being said, I feel like I have joint custody of my daughter, and I haven't bothered Lyric about it because I don't want to get in trouble with the courts. So I bring it to you guys. And like I said, we would have times, and then we have times that she had vanished. So we thought she had come around eventually, and I seen she wouldn't. So with that being said, that's why I put the court order in the verdict.
Okay, well, in this particular matter, she's asking for a number of things. She's asking for sole legal custody, that parenting time be changed, and that she has a change of domicile to allow her to move to Arizona. Are you contesting and disputing all of those things?
I am.
Okay.
Because I have college in fall. I have things going on for myself as well. So if that was the case, I would have been moved, but I'm here for my daughter.
Okay. Well, what the court's going to do is, obviously you're contesting, the court will set up for an evidentiary hearing where the court does believe that there's sufficient factual basis pursuant to the Varka threshold to, again, have an evidentiary hearing. So we'll have a hearing on the matter, and at that time, we'll present everything each of the parties have to present, and then the court will make a decision. So
is my custody, my parenting time still the same?
it's all the same. I'm not changing it until we have a hearing.
Okay, so from here, where we going? Nothing's gonna happen from here?
Well, we'll set up a hearing, and then the court will have a hearing on it.
Okay.
So we'll be in touch. Do we have Mr. Wine's phone number?
I'm not sure. He can contact our office.
Mr. Wines, contact our office and give a phone number. And then what we'll do is we'll work out some dates with you and Mr. Umlauf, and then we'll set up the hearing date. Okay?
Yeah. Thank you.
Thank you. Go. Have a good day. Court will note the appearance of Mr. Umlauf on behalf of plaintiff. This matter is before the court on the plaintiff's motion to show cause. In this matter, court does note that it's 9:43 a.m. This matter was set for 9:30. The defendant has not appeared. In this case, the court notes in reviewing the motion in this matter that again, there was the order had required the transfer of the real estate to your client, Mr. Umlauf, and that hasn't accomplished because apparently the defendant has not cooperated. So what the court will do is the court will grant to you, Mr. Umlauf, an order transferring the real estate to your client. So we do not need the involvement or the approval of the defendant. The court further will grant to you the attorney fees and costs necessitated in this motion. I don't know if you want to include that just in the order, if you know what that is, Mr. Umlauf.
It would be 525 hours. However, I anticipate that will go up due to attending and also preparing an order. I anticipate that would go up to 800, Your Honor.
Okay, the court will order and provide you with $800 towards attorney fees and costs. The court will order that be within 45 days of today's date. Mr. Umlauf, you can include all of that in the order and submit under 7-day notice.
Thank you, Your Honor.
Thank you. You're free to go. Have a good day. Court will note the appearance of Mr. Umlauf on behalf of plaintiff. This matter is before the court on the petition of Mr. Umlauf's office to withdraw in this case. Ms. Martin, are you opposed to the withdrawal?
Morning, Judge Kirkham. I plan on signing off on Jennifer's withdrawal as counsel. However, I wanted to attend this motion hearing to ask you a couple of questions.
Okay, well, if it's anything I can answer, I'll do that.
My main concern and question is, let's see here, hold on. Can you please adjourn the mediation and settlement conference 4 to 6 weeks to allow me to find new counsel? I'm having difficulties finding a new attorney because we are so far into the divorce process and the divorce is messy. 2 attorneys have turned me away now for these reasons. I'm not looking for an attorney to ride in on a white horse at this point. I know that's not realistic. I'd be happy if I can find an attorney to ride in on a donkey and salvage the mess Jennifer has gotten me into.
When is,
It's scheduled for August 22nd.
you basically almost have a month and a half. You can't get an attorney.
No, I've already had 2 turn me away because they said you're so far into the divorce process and because it has been a contentious divorce that they would not take me on. I do have a couple of consultations set up for this week, but I do have genuine concerns about finding a decent attorney at this point.
Checking to just see how old the case is right now.
112 days.
Okay, well, we have some time. What I'll do is, that'll put us at the limit. What we'll do is I will grant your request and we'll move the mediation to October. I won't move it beyond that, so just so you're aware that you go ahead with it or not, but I'm not gonna move it beyond that date.
Okay, is there,
So I don't know without them being.
Yeah. Okay, Mr. Umlauf, I'll let you contact whoever the mediator is, and if you would just cancel that, say they'll, when she gets other counsel, that they will contact they'll contact the mediator and change that particular date.
We can do that, Your Honor.
And you said you had a couple questions, ma'am?
yes. Okay, so, my question is, my soon-to-be ex-husband's attorney, it sounds like they're going to be filing more motions. If we sign off, and if I don't have an attorney right away, when Cindy Thomas files these motions, do I end up just representing myself in the meantime until I can?
You're gonna have to, because again, it's adjourned. I'm not gonna just adjourn out their motions endlessly until you get a counsel, because I don't know what the would be, so I don't know if any of them are timely or anything like that. If in fact you get limited, let's say you should acquire a counsel and the counsel can't appear at a motion, you can always appear and ask to move that motion hearing, and we'll do it on an individual basis.
Okay. And then one more question. Now that Jennifer will not be my attorney, do I need to reach out to Cindy Thomas and give her my contact information then?
You should at this point, so that she can make contact with you, because otherwise she would just send things to Miss Reed.
Your
Okay.
Honor, if I may.
Yes,
The order to withdraw as counsel has plaintiff's current address.
okay. Okay, you should be, then Miss Thomas would get in touch with you at your address.
Wouldn't she need my cell phone number to be more efficient?
So it's up to you, but if she's gonna file a motion, she'll have to send notice to you. She wouldn't need your cell phone for that.
Okay, I wasn't sure how quick I would need to know. Thank you.
Okay?
Okay,
Mr. Umlauf, you can get the order in and we'll get it entered.
Your Honor, I believe we already submitted the order.
Okay,
I'm sorry, excuse me, what order?
what, ma'am?
I'm sorry, what order was submitted?
Order allow them to withdraw.
Oh, okay,
They submitted it with the motion.
okay.
We will get that entered today, and then, ma'am, work with, trying to get your other counsel now that matter's been moved out to October.
Okay, and again, that was for mediation, correct?
Yes,
And the
correct. And what?
Okay. And the settlement conference?
We'll set the settlement conference sometime in later October then.
Okay, can I ask one more question, please?
Sure.
I did file a motion for an emergent ex parte. My husband has been using our insurance claim money from the hail damage. It's $29,000, and he's been using it to bankroll his attorney and spend it on other items. Is there any way to prevent him from further spending that money?
You'll have to file a motion,
Okay,
okay? I'm not at today. It's not scheduled today, so I won't hear it today.
okay.
Does she need to prove an order moving mediation?
No, I had Mr. Umlauf contact the mediator and cancel that. And let Mr. Umlauf, if you would let Ms. Thomas know that as well.
Certainly, Your Honor.
Okay, thank you. Free to go. Have a good day.
Amanda Luna Jennifer Bailey versus Brian Bailey.
Court will note the appearance of Mr. Umlauf on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. The court notes that it is 9:53, was set for 9:30. The defendant has not appeared, nor has the defendant filed any pleadings in this particular matter. As a result, Mr. Umlauf, the court will grant your request for relief by default. So the court will grant to the plaintiff temporary custody in this matter based on the maintenance, if you would, of the status quo. The court notes that the petition in this matter shows that then had been absent since sometime in November of 2023, only had sporadic parenting time in this matter. So the court will grant that motion. The court will grant requests for child support pursuant to the guidelines in this matter. And Mr. Umlauf, what are your thoughts on on parenting time at this point on a temporary basis?
Your Honor, we requested reasonable supervised parenting time at the recommendation of the children's counselor in our motion, and we would stand by that.
Okay. Well, the court will at this point till we have, again, unless the defendant files a motion, we can address that at that time. On a temporary, we'll just state that it'll be by supervised parenting time as arranged by and between the parties. And then we will address it if in fact the defendant brings the matter before the court.
Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Tanisha Mendelson versus Wesley Jackson. It's Monday, July 8th, 2024 at 1:43 p.m. Attorney Basson for the plaintiff. I do not have defendant or defendant's counsel.
Okay, Ms. Basson, enlighten us. What's happening and why don't we have anybody here for the defendant?
I have no idea as to the defendant, Your Honor, as to what's going on in the case. I am still missing discovery documents that are very, very late at this point. We do have mediation scheduled, but have not attended mediation. It was scheduled once before and defendant did not pay the mediator. It has been rescheduled for the 23rd of July. That's where the case is there has been no progress due to responsiveness from
Okay.
defendant.
What I'll do is the court will reset this for 30 days. Only at that time, hopefully the mediation goes forward. If it doesn't, you can enlighten us at that time and then we'll decide at that time how we're going to proceed.
Understood, Your Honor.
Okay, thank you. My understanding in this case that the mediation was canceled as neither party paid the mediator. And as a result, if that happens, and unless you have a resolution, then we would set the matter for trial. I'll go to you first, Mr. McKediak. I assume you're not settled in this matter.
I mean, she's not. I'm not really asking for anything but the divorce to be final and for you, Your Honor, to set visitation with my son.
Okay,
As far as the house, all the material things, I pretty much left it to her already and let her keep everything. I don't want nothing to do with it or her. She can have the house, she can have whatever else on that end from when we were together. Because during the marriage, we were only living together for 9 months.
okay,
First and second are open.
okay. Ms. McKediak, is that your understanding is we're going to have to try the case?
Yes, because that is not true.
Okay. Okay. Well, what he's saying is there are no issues in dispute as it relates to property and that you can have apparently all the property that you have, including the real estate. So I don't assume you're going to argue about that. Is that correct?
I owned the property before we were married, regardless.
Okay. I'm saying he's saying he's not making a claim to that property. He's disputing that, or do you
No.
want to give him some property?
No.
Okay, that's what I'm asking you. So there's no dispute as it relates to any property issues, correct?
Correct.
Okay. Is there a dispute as it relates to parenting time?
Yes.
Okay. Then we will set the matter for trial. I'll ask both of you, are you available on Thursday, August 1st or Friday, August 2nd? We'll set the trial one of those days.
Yes.
Ms. McKediak?
I'm looking right now. Hold on. I should be available Friday.
Friday?
Yes.
Okay, we'll set it for Friday, August 2nd at 8:30 a.m. And be prompt because we do start at 8:30 promptly. So
Is that in person, Your Honor?
no, we will do that vis-a-vis Zoom.
Okay,
If you have, obviously, we had a case in order, so make sure you comply with that as it relates to all the issues for trial, but we will set it for Friday, August 2nd at 8:30 a.m.
Setting up
All
a
right.
thank you day, Judge? Or one,
Doesn't matter. You'll just set it for this one second.
okay, I'll set up for all day.
Okay? With that, I'll let you go. Have a good day and we'll see you back on August 2nd.
you too. Thank you.
All right, thank you. And
Shayla Kuykendall versus Aaron Gorman. Today is Monday, July 8th, 2024 at 10 a.m.
Court will note the appearance of Mr. Murphy on behalf of the defendant. This matter is before the court on the defendant's motion for change of venue. Mr. Murphy.
Yes, Your Honor. At this point, we stand by our motion. It seems like the children do spend the majority of their time in Berry County. We actually did a count, and from January of last year to January of this year, they spent 199 days with the defendant here in Berry County. One of the children is enrolled to begin school this fall. He is enrolled in school in Berry County. The address provided to the school was a Berry County address. The address provided to doctor's offices when they attend doctors is a Berry County address. And we contend that they reside in Berry County. Therefore, we're asking this court to transfer this action to Berry County for it to be tried.
Okay, thank you. Ms. Kuykendall, what's your response?
We do 50-50, so it's week on, week off. We switch every Sunday. The kids would be enrolled in I think Battle Creek is Calhoun County, but Aaron said that he did not want the kids to attend those schools, and we tried to enroll them in Nashville, but they said that they couldn't because they go off county, and Aiden wouldn't have been able to start school until October. So me and him agreed to have the kids just do Hastings, and I drive them back and forth to school.
Okay,
And yes, their address for the hospital's Aaron's address because Aaron lives in Hastings and their doctors are both in Hastings.
okay. Well, in this particular matter, the court does note again that the plaintiff resides in Calhoun County. She had resided in Calhoun County when she filed the action. And this particular matter, this applicable statute is MCL 722.26, which provides that if a court does not have prior continuing jurisdiction, that it can be submitted to circuit court in the county where the child resides or may be found. And in this case, as stated by the plaintiff, it appears that's uncontested that the parties are sharing custody on an alternating basis. The court does not find that Calhoun County is improper. And pursuant to Michigan Court Rule 2.223 parens A provides that a venue in the civil action is improper, that the court can change it. Court does not find that it's improper venue in this particular matter. So at this point, without something more, the court will deny the motion for change of venue in this matter. The case will proceed in Calhoun County.
Yes, Your Honor.
Okay, Ms. Kuykendall, you're going to have to, because you're representing yourself, you're going to have to prepare an order stating that I've denied the motion for change of venue, and you'll have to submit that within 7 days of today's date under a 7-day notice, okay?
How do you do that? Sorry.
Well, I can't give you legal advice, and that's the
Okay.
problem when you're representing yourself. You're going to have to look it up. If you go on michiganlegalhelp.org, they have various orders and forms, etc. They would be able to potentially assist you, but it's all going to be online, okay?
Okay.
Thank you. You're free to go. Have a good day. Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's objection to the referee ruling in this matter. Mr. Pattison, you state in there that the parties agreed to, and I quote, split parent and expenses equally 6 months a year. I guess I don't quite understand all of that. What are you saying?
Yeah, we wanted to split everything straight down the middle. The parenting time and everything, expenses, everything straight down the middle.
Okay, well, when you split, you say that, does that mean that you're going to have joint legal and joint physical custody, or what? You haven't addressed that, just the expenses.
Yes, that too.
Okay, Ms. McCray,
Yes.
Ms. McCray, is that your understanding and is that your agreement?
Yes.
Okay, well, with that, Mr. Let you chime in. What are your thoughts?
Well, I guess I would interpret what's happening today as an agreement to modify existing order. I can only indicate that at the referee hearing back in May, both parties appeared, the court took testimony. The support order was based on the findings of the referee utilizing 120 overnights. So if there's something different, then that's fine, but I would simply ask that the order stand. Any future orders that modify the order can be prepared, obviously, by the parties as they go forward.
Okay. Mr. Patterson, that's kind of the position the court was going to take in this matter, is that, again, you and Ms. McCray can come up with any sort of agreement that you want, and if the court's not going to, again, be an impediment to that, but what happens if that doesn't change the referee's order? So you're going to have to do an order modifying whatever the order is of the referee. So you'd have to do an order modifying, custody, parenting time, support, etc., and state effectively what you're saying, that both parties would have joint legal and joint physical custody, state whatever the parenting time schedule is, and then you'd have to do a child support order too, which would reflect, again, the respective incomes of the parties, etc. You understand that, sir?
Yes.
Okay. Because you're representing yourself, you're like the attorney, you've got to prepare the orders. If you know how to do that, you go to some services such as MichiganLegalHelp.org, and that service will have all those orders in there, and you'll just have to enter the information, etc. So you can do that and then submit that to Ms. McCray. If she signs it, you'll need to submit it to the front of the court for their approval. And when the front of the court approves it, then the court will approve it at that time, okay?
Okay.
Do you have any questions, sir?
Yes, I thought I demonstrated the established, custodial environment, and I've been an intricate part of living every day, and I did not want to disturb that.
Well, that's academic at this point, because you say you and Ms. McCray are going to enter a new order. So regardless of what the referee determined, you're doing a new order. So I guess I don't have to get into that at this point.
Okay. All right.
Do your new orders and have Ms. McCray approve it, submit it to the front of the court for their approval. And then once we have that approved, the court will enter it. But and the referee order will stay in place until such time as you change it with that order.
Okay.
So get working on it, do it right away, and then we'll be able to get it changed relatively quick.
Okay. All right.
Okay. Ms. McCray, any questions you have?
No.
Okay. Thank you. And anything else, Mr. Magnuson?
No, thank you, Your Honor.
I've been arrested for a DUI. I just had a baby and I went out with some girlfriends. He hasn't seen her for 3 months.
I just want to be able to see my daughter. And now I've tried for 3 months almost and with nothing.